We've got Robert Leonard, who's a labor relations specialist with AFSCME, Council 66. We've got Bess Watts, who is the president of CSCA, that's the Civil Service Employees Association, ATA. We've got Kenny Montgomery, who's the president of the National Association of Letter Carriers. At the end, we have our distinguished I still think of you as recently retired, Jim Bertolone, past president of the Central Labor Council. I'm pretty sure that Tom Gillette from the New York State United Teachers recently retired and will be joining us. But that's it in a nutshell. We would appreciate it, because everyone is speaking to the same issue today. We would appreciate if you would hold your questions or comments until the end of the presentations, because the question that comes to your mind while Harry's speaking may actually be answered when Robert is speaking. So please hold your questions and comments till the end. We have deliberately left time for questions and comments. So without further ado, Harry, I'm going to ask you to step up. Thanks.
Good morning, everyone, and Linda, thank you for making the introduction and having me here today, and thank you all for coming. And before I actually get started in my remarks, I want to point out that one of my colleagues is in the room, and Assemblymember Mark Johns. Everybody should welcome Mark Johns.
I didn't want to be late for Harry's speech. So.
I know that's why you're here, Mark. So, as I understand my role here is to give introductory remarks and to, in a way, set a framework for the discussion around Janus versus AFSCME. And so I'm going to touch mostly on the surface level, with the exception of some legal implications that aren't necessarily directly related to labor. But I'm going to talk a little bit about the funding of unions and the impact of this decision, about the membership levels of unions, and with a possibility of a reduction in membership, which would then turn into a reduction of the power that we have as unions. And as I indicated, the legal implications that are really what the balancing is on constitutional protections within the public workplace. And lastly, the race to the bottom, not only for unionized workers, but our entire workforce. So I'm going to briefly talk about those things and how it relates to all of you. But to begin, I think it's important for us to acknowledge the context in which we're living in the labor movement right now, and in which this case is being decided. Particularly, organized labor is under attack. You all know that. We're facing threats on multiple fronts. A majority of states now have so-called misleading right-to-work laws. Workers continue to reject organizing on a regular basis. And technology is replacing humans and their jobs. And at the very least, if it's not replacing, it's definitely changing the nature of our work. To make matters worse, we have a federal government which is promoting big business and profits at the expense of workers, notwithstanding campaign promises otherwise. And within this context, unions, the labor movement, and more devastating, workers are facing another possible and significant blow by this decision from the United States Supreme Court. Janus versus AFSCME arguably is one of the most significant labor law cases in decades. This case in all likelihood would change the ability of workers to successfully fight for job security, better pay, working conditions, workplace safety, and benefits, such as good health care and retirement benefits. As most of you know, this past Monday in Janus, the Supreme Court heard oral arguments on whether to end mandatory agency fees from public employees who are not members of the union, but get benefits from the union. So a narrow look at the Janus case suggests it's merely about those agency fees and the ability for unions to collect those dues. But it's much more than that. So let's look at the case first of all. So it involves Mark Janus, an Illinois state government worker who argues that payments he's forced to make, agency dues or fair share dues, those payments violates his constitutional right to free speech. And it forces him, through paying those dues in his mind, to pay for political speech that he doesn't support. And for him, in his position, that violates his First Amendment rights. The problem is that Janus isn't actually being forced to pay for so-called political or lobbying activities of the union. Instead, what Janus and other public employees who typically sign a letter saying that they're going to opt out of membership, they're paying for the benefits. They're paying for the representation. And the difficulty with this case, though, and it's a unique argument. In this case, Janus is also saying that collective bargaining in and of itself is political activity. And they're saying that because through the collective bargaining, it's requiring government to expend funds in a certain way, and that has political ramifications, that the collective bargaining in and of itself is the free speech. So that's going to be the crux of what the judges are going to have to look at, and whether or not we're going to expand the previous Abood, I think is how you say that, previous Abood case from '77, I believe. And as most of you know, that just 2 years ago, we had a similar case, a California teacher who brought the case, and that case ended up in a 4-4 tie after Justice Scalia passed away. And so the status quo remained and agency fees remained, but the issue was left open. And with Trump's appointment of Justice Neil Gorsuch, who is quite conservative, arguably more conservative than Scalia, that we know where the decision's going to go with a 5-4 loss to the labor movement. And at issue really is these laws in 22 states, including New York State. And so this is going to impact a lot of workers across those 22 states. So without the agency fees, we have what I'm going to call non-union free riders. And these are the workers who are going to benefit from union collective bargaining and union representation, but they're not going to pay for it. And by depleting those union funds, you're depleting unions' abilities to deliver on their representation, and ultimately it will make those unions weaker, in part because, and I'll talk about it a little bit more, in part because the numbers are going to be reduced. And as Assemblymember John knows, that every time we get a memo in support from AFSCME or CSEA or PEP, it always starts with the number of union members that they're representing. So those are the number of voices that they're speaking on behalf of. So a ruling in Janus' favor could cut public unions off at their knees, significantly reducing both their funding and membership. Many union advocates, including myself, worry that workers will leave the union knowing that the union's bargaining efforts will continue to benefit them for free. I'll talk a little bit more about that, but let's talk about the warring parties here. Who are the warring parties? I mean, obviously we know on our side, it's brothers and sisters in various unions, both the public and the private sector, who are fighting for workers' rights. But the folks who are fighting for the so-called right to work, in my last count, I think there were 2 more states that fell last year in 2017. That brings us up to 28 states that now have right to work laws. That's being waged by wealthy, elite, and corporate business interests who don't want strong unions because strong unions give workers a voice on job conditions and pay and on benefits. Those pushing the Janus decision want to weaken unions because if they do, they have an opportunity to roll back pay and benefit gains of the workers. Without strong unions, the CEOs and wealthy business owners can keep more profits for themselves. It really boils down to this. They want to race to the bottom so those at the top can pad their own pockets. So other implications of this decision. So far I've been mostly talking about the labor movement, but if you'll allow me to be a lawyer for just a minute, okay? And let me talk about the implications of making this decision regarding balancing constitutional rights of public employees with the rights of the public employer. So, and I'm not going to get into too much of the legalese, but union agency fees don't exist in a vacuum. They exist in a context of law that has been developed over the last decades that has evaluated the constitutional rights of each and every citizen with where do those rights come to play when that citizen is in the context of a public employee, and how is that balanced with the rights of an employer for whatever legitimate workplace interest that employer has. And so we have roughly 21 million public employees in this country, and this law has developed with that balancing act over many, many years. So, let's look at a couple of examples. So, a teacher who's out sick, sub comes in, and the teacher hasn't left a note on where the lesson plans are for the day. So whoever is responsible for administering that school needs to find the lesson plans, right? We need something for the teacher to teach and the kids to learn. So the employer desires to go into the teacher's desk. What's the right of privacy to the teacher with the contents of the teacher's personal desk? What's the interest of the employer to be able to go in that desk and look for the lesson plan? So the courts have decided this. They said there's no violation of the Fourth Amendment. You know the Fourth Amendment, no unreasonable search and seizure, right? So there's no violation of the Fourth Amendment for a couple of reasons. Number one, the teacher has that desk in the context of a public employee, not in the context of an individual citizen. Second, there is a legitimate workplace need to go into that desk. So the courts have balanced that scenario. When I was practicing law full-time, one of the last cases I had was a physician that worked at a public hospital. The physician was very concerned about the level of quality of care that was given to the patients in that hospital. And he ultimately reported the hospital to various oversight agencies here in New York State. After those reports became known by the hospital, his hospital privileges were terminated. He was fired. So we brought a lawsuit claiming that he had a First Amendment right to whistleblow, right? And we also complained, and we also argued that, and this is the distinction, he didn't make those complaints because he was a physician at the hospital. He merely knew of the problems because he was a physician at the hospital. He made the complaints as a citizen who has an interest in hospitals providing good quality health care to people who come into the hospital. The hospital argued that they had a workplace interest in keeping things calm and peaceful in the hospital, and that this physician was disruptive because he was always complaining while he was in the hospital. So ultimately, we won the case because it was determined that his speech was as a citizen, and his speech really had a public interest to it. So that's where we're at with First Amendment rights in the workplace. So distinguish that case from the Janus case. The Janus case is saying, I don't want to pay fees because it violates my speech. So, and what Janus is saying is it violates my speech because unions take positions that I don't agree with. That is okay. That is probably. We'll see where the case comes down on that. What I'm more concerned is the argument where he's saying, through collective bargaining, which I'm paying for, they're forcing the state to do something that I disagree with. Interestingly enough, though, and I just saw 2 minutes, right? Interestingly enough, keep in mind the state makes us pay for all kinds of stuff. The state makes us pay for car insurance. The state under ACA makes us pay for health insurance. The state makes us pay for me, I have to have continuing legal education every couple of years, right? So the state makes us pay for things all the time, so we'll see where that goes. So the bottom line is this. I spent a little bit of extra time on the legal stuff because I know everybody else is going to talk more about the labor movement. But members are going to be encouraged not to, or people are going to be encouraged not to be members. And Linda Donahue actually shared this with me, and I'll share it with you. Why the heck would anybody want to pay for dues if this case says you don't have to? Right? Think about it. You buy your automobile insurance, mandated by the state, by the way. You buy your automobile insurance and you get the benefit of coverage of that insurance because you paid for the premiums. If you could get the benefit of that insurance without paying for the premiums, what's most reasonable people going to do? Not pay the premiums because they're still going to get the benefit. That's the hurdle that you're all going to be facing here, and I hope some of my colleagues here will talk about the importance of encouraging members and talking to members about the values of unions, about the value of brotherhood and sisterhood, about the value of being united to fight against, more often than not, management that wants to bring us down versus giving us workers' rights. So that's where the battle lines are going to be drawn if this decision is ruled the way I think it's probably going to be. So I look forward to your questions, and thank you very much for having me here today.
Thanks, Harry. And we actually have reason for optimism, nonetheless. And the voice of optimism here today is Kenny Montgomery, President of the National Association of Letter Carriers, Branch 210.
Believe that. I'm the optimist.